The hearing will resume, and we now turn to Senator Feingold for 20 minutes.
Thank you, Mr. Chairman. Good afternoon, Judge. I hope if nothing else you associate me with breaks in the proceedings, because it seems to happen every time my questions are up. Judge, yesterday I asked you about your preparation for these hearings over the past few months with a variety of practice sessions. You confirmed that you had had these sessions and that a great variety of subjects came up in them, and that's fine. I know this is not an easy process, and I would certainly expect you to prepare in this way. What I want to ask now, though, is simply if you can provide a list of all the people who participated in any of those practice sessions. And I would request that the folks here sitting behind you and back at the Department of Justice help you put that list together this evening and get it to us tomorrow morning so that we have time to ask about it during tomorrow's session if necessary. Can you do that for me, Judge?
I certainly have no objection to that.
Thank you very much. Now I want to get into the subject, a subject that really requires some attention here and hasn't had much attention given the important role that it plays in the job of Supreme Court Justice, and that is the issue of capital punishment or the death penalty. Judge Alito, the idea that defendants are entitled to effective legal representation is a fundamental part of our criminal justice system. In fact, of course, it's enshrined in the Sixth Amendment's guarantee that the accused have, quote, the assistance of counsel for his defense, unquote. Nowhere is this guarantee obviously more important than in cases where the defendant's life is on the line. And in a death penalty case you decided in 2004 called Rampila versus Horn, you rejected the defendant's argument that his attorneys had failed to do an adequate investigation to prepare for his sentencing hearing. As a result, key mitigating evidence about his horrible childhood was never presented to the sentencing jury, which ultimately sentenced him to death. As you know, the Supreme Court reversed your decision, ruling that the defense attorney's failure to even review evidence they knew the prosecution was going to introduce at sentencing violated the Sixth Amendment. This case was one of several Supreme Court cases in recent years to express particular concern about the adequacy of indigent representation and the fairness of the capital sentencing process. In fact, in several recent decisions, including Rampila, the Court has overturned death sentences because defense attorneys did not do adequate investigations to turn up potential mitigating evidence and because jury instructions did not clearly allow jurors to consider any and all possible mitigating evidence. And Justice O'Connor, who you have been nominated to replace, has of course often been the author or the deciding vote in these cases. Judge, what are your views on these issues? Is the Court's recent emphasis on the importance of fully developing and considering mitigating evidence in capital sentencing proceedings headed in the right direction?
It is vitally important that all criminal defendants receive effective representation, and I could not agree with you more strongly that this is of the utmost importance in death penalty cases where so much is at stake. In the Rampila case that you mentioned, we had to apply the standard of review that is set out in the habeas corpus statute as revised by Congress. And where there has been a determination on the merits by the state courts on an issue like whether a defendant received effective representation within the meaning of the Sixth Amendment, and where the state courts have applied the correct legal standard, we are not allowed to disturb their decision unless what they did was unreasonable.
Well, let me ask you then, because you're obviously pointing out the fact that you approached the Rampila case as an appellate court judge bound by prior Supreme Court precedent, and yet you found that no constitutional violation had occurred. And I believe when we discussed this case in my office, you indicated you still think your decision was correct. So the question now is, would your approach have been any different as a Supreme Court justice? What about your decision on the outcome of the case?
Well, my decision, and I spoke directly to the issue, in the Rob Pila case as I saw it when it came before me. And my evaluation of the performance of the attorneys in that case was fully set out in the opinion that I wrote. They were, one of them was a very experienced criminal defense attorney. He was the head of the public defender's office, and there was no dispute whatsoever that this was an attorney of competence and experience and great dedication to the defendant in this case. And that attorney was assisted by another attorney in the office, and together they were extremely dedicated to this case. Now, there was a number of judges took a look at this. All of this, the Pennsylvania judiciary, with the possible exception of one justice, I can't remember clearly whether there was one justice who disagreed, thought that there had been effective representation provided in this case.
Well, this really isn't about the difference between being on the Court of Appeals and the Supreme Court. You apparently would have, based on what you know here, would have ruled the same way had you been on the Supreme Court.
Well, my evaluation of the facts of the case would be the same. Now, if the case
In other words,
came
that there was not a violation of the
if-
Sixth Amendment.
Well,
Correct?
but I should add, however, that if a case came up in the future, the Supreme Court's decision in that case is a precedent that I would have to deal with. And they
Fair enough.
expressed the view as to how the standard applies to the facts of the case. It was a 5-4 decision, but it would be a precedent that I would follow.
Well, then let's go back to my original question, which is, do you think the Supreme Court has been heading in the right direction in these cases?
Well, I think that the Supreme Court is correct in viewing this as a very important part of the criminal justice system, and in particular, a very important part of the representation of clients in Eighth Amendment cases.
Isn't the Court doing more than that? The Court is moving in the direction of giving greater recognition and ruling on the inadequacy of counsel in these cases.
And I think it's entirely appropriate that there be a searching review in every case as to whether a defendant, in any criminal case, but in particular, of course, in a capital case, has received the representation that the defendant is entitled to under the Sixth Amendment.
Do you think you're replacing Justice O'Connor will change the direction of the Court in this regard?
I would approach these cases under the law that the Supreme Court has established in this area, with the recognition that I've attempted to explain of how important I believe this right is in all cases, and in death cases in particular. And the Supreme Court, when the Supreme Court reviews a case that's come up through the federal system, in a habeas proceeding, then the Supreme Court, just like my court, should apply the standards that are set out in the habeas corpus statute.
Let's go to a different one. Wiggins versus Smith is a Supreme Court case decided in 2003, also addressing an inadequate mitigation investigation. In that case, Justice O'Connor, writing for the majority, found trial counsel ineffective for failing to conduct an adequate investigation into possible mitigating evidence that could be presented at sentencing. Had the attorney done adequate investigation, he would have found abundant evidence of childhood, physical, and sexual abuse, as well as diminished mental capacity. Do you think that case was rightly decided?
Well, I discussed Wiggins in Rompila, and I thought that it was distinguishable. Wiggins, as described, as I recall it, was a case where the attorney had reason, the attorney simply didn't conduct an investigation without any sound strategic reason for not investigating a particular matter.
So you have no sense that that was wrongly decided?
I have no sense that that was wrong. I thought it was different from the Rompila case.
According to two independent studies, your record in death penalty cases has been more anti-capital defendant even than most Republican-appointed judges. In fact, in every disputed capital case that you heard, that is, cases in which a panel of 3 judges did not all agree, you would have ruled against the defendant. How do you explain this seeming tendency to favor the government in capital cases?
I've only sat on a handful of capital cases, and in some of them I voted to uphold the death penalty, and in a number of them I voted to strike down the death penalty. In Carpenter versus Vaughn, I voted to strike down the death penalty. In the most recent death penalty case I sat on, the Bronstein case, I voted to strike down the death penalty because of the procedure that was followed at the penalty phase in that case. In the Cruz case, I was part of a panel that vacated a decision of the district court rejecting the claim of a habeas petitioner. There have been other cases where I voted to uphold the death penalty.
Justice Stevens recently gave a speech to the American Bar Association, in which he raised a number of serious concerns about the administration of the death penalty. He pointed to aspects of capital proceedings that he believes unfairly tilt the balance in favor of the prosecution, both at the trial and sentencing stages. Specifically, he raised concerns about the jury selection process, arguing that jurors are questioned so extensively about the death penalty that they might assume their role is primarily to decide the sentence for a presumptively guilty defendant. He also argued that a representation of indigent defendants remains an issue that has not been adequately addressed, and he noted that elected state judges may have a, quote, subtle bias, unquote, in favor of death because they have to face re-election. Now, I know all of us on this committee have the greatest respect for state court judges, but we all can understand the pressures of a re-election campaign. So what are your views on the potential of these three issues, the jury selection, the inadequate representation, and an elected judiciary to skew a capital prosecution against the defendant? And do you share these concerns that Justice Stevens outlined?
I certainly share a concern that there should be a fair procedure for the selection of jurors. That certainly is a concern. The issue of the election of judges at the state level or the appointment of judges at the state level is a matter for state legislatures to decide. And within my circuit, we have 3 states. In New Jersey and in Delaware, the state judiciary is appointed. In Pennsylvania, the state judiciary is elected. And I've had the opportunity to view the work of all 3 of the Supreme Courts in those states, and I think they all are of a very high quality. I think the elected judges in Pennsylvania do a conscientious effort to carry out their responsibilities, and I think I have a high regard for the judiciary in all of those states. So based on the experience on my experience, I think you can have highly competent and certainly conscientious state judges who are appointed and the same sort of judges who are elected. And of course we do have habeas corpus, and it is it's important to make sure that constitutional rights are respected, and the scope of the review that we conduct under habeas is up to Congress. Congress reformulated the standards in EDPA, in the Anti-Terrorism and Effective Death Penalty Act of 1996, limiting our review, and it's our obligation to conduct the kind of review that Congress has indicated we should be conducting.
Well, Judge, it sounds like you perhaps have a lesser level of concern about some of these matters than Justice Stevens. The only thing I would note is that one of the most striking things about the history of justices that have gone to the court sometimes who are pro-death penalty, an amazing number have come to the conclusion that this is the one area where once they get there, they realize that these problems are much more severe than they might have thought before they became Supreme Court justices. And I, should you be confirmed, look forward to how you react to these issues after you've become a Supreme Court justice, should you do so. In the past few years, the Supreme Court has limited the application of the death penalty based on the Eighth Amendment's ban on cruel and unusual punishments. In Atkins versus Virginia, the court ruled that mentally retarded inmates cannot be executed. And in Roper versus Simmons, it held that individuals who were minors when they committed capital crimes cannot be executed as punishment for their actions. Do you agree with these decisions?
Well, those decisions applied the standard that the Supreme Court formulated sometime earlier in determining whether the imposition of the death penalty on particular categories of defendants would violate the Eighth Amendment, and they look to evolving standards of decency, and that is a line of precedent in the Supreme Court, and those are precedents of the Supreme Court, and they're entitled to the respect of stare decisis.
Can you just tell me what your general approach to the Eighth Amendment would be in the context of the death penalty?
My approach would be to work within the body of precedent that we have. As I mentioned earlier, the Supreme Court has devoted a lot of attention to this issue since 1976, when it held that the death penalty is permissible, provided that adequate procedures are implemented by the states so that the decision about who receives the death penalty and who does not is not arbitrary and capricious, so that there is a rationality to the selection process. And the rules in this area are quite complex, but I would work within the body of precedent that is available.
Let me go to a topic that we've talked about before. We had a good discussion of the recusal issue in the Vanguard case yesterday, and I intended to ask more about it, but your discussions with Senator Kennedy and Senator Hatch today make further questioning a little bit necessary. Senator Hatch noted that the committee's questionnaire asks about financial conflicts of interest during the period of your initial service as a judge. Now, the reason for wording the question like that, of course, is that nominees have no way of knowing when they are up for confirmation whether they will have the same investments 5, 10, 25 years later. The committee obviously can't ask for a comprehensive list of possible future financial conflicts. So, for example, if you have stock in Microsoft and you list that as a financial conflict on your questionnaire, you still have to recuse yourself from a Microsoft case 15 years later if you still have the stock. Isn't that right?
If you're required to recuse yourself, if you have stock in Microsoft, even one share,
you still have to recuse yourself even if it's 15 years later, right?
Certainly that's true.
So the question in the Senate questionnaire about financial investments is not time limited based on the question being about initial service on the court, is it?
Well, I want to be clear on my answer respecting this as it bears on the manga case, the Vanguard case, because that's what we're discussing. The wording of the Senate questionnaire was not the reason for the way I handled the case. And I've tried.
I just want to know if there's you have any question in your mind why the question's phrased that way on the questionnaire.
Reading the question, it does seem to me that initial period of service is a temporal limitation.
I want to be sure we don't leave the impression from these hearings that people don't have an obligation to recuse themselves from a financial conflict just because of the passage of time. You've already indicated if that financial conflict continues, that's an indefinite and permanent restriction until that financial holding is gone, isn't that?
Absolutely, and that's under the Code of Judicial Conduct, Canon 3C3, I think it is.
Okay.
If you have a financial interest, you must recuse yourself, and that's, of course, a continuing obligation.
It's not temporal.
The obligation to comply with the Code of Conduct for federal judges applies to every federal judge for as long as they serve.
And that's why I have to say that I'm a bit frustrated that people are trying to obscure what I think was pretty clear testimony by you yesterday by bringing up this period of initial service issue. In response to Senator Kennedy, you made it clear again that your failure to recuse in the Vanguard case had nothing to do with this suggestion that your promise was time limited. But I want to get this on the record again, and hopefully this will lay any confusion to rest. This idea that your promise to the committee was somehow limited to your initial service on the court, that was not the reason you failed to recuse yourself from the case in 2002, was it?
It was not the reason in 2002. I do think, reading the question, it has a temporal limitation. If that wasn't the intent, I think people could read it, certainly. When you say initial period of service, people will read that to mean
temporal limitation. This has nothing to do with why you didn't recuse yourself.
It did not have to do with what I did in the manga case.
And it's not as if you noticed that Vanguard was a party, remembered your promise to the committee, and then made a specific decision not to recuse because the promise had expired.
No, it was not that at all.
And you finally added Vanguard to your standing recusal list in December 2003, and it's on your list today, isn't that right?
It is on my list today.
Do you plan to recuse yourself from Vanguard cases that come before the Supreme Court if you are confirmed for as long as you keep your Vanguard mutual funds?
Well, if I'm confirmed, I will very strictly comply with the ethical obligations that apply to Supreme Court justices. Supreme Court recusals are a bit different from recusals in the Court of Appeals, and so the obligation to sit when you're not recused is one that has to be considered very seriously by somebody on the Supreme Court, or I would think on a state Supreme Court, for example.
Is there any question if you still have holdings in Vanguard and a case comes before the Supreme Court that you should recuse yourself?
Well, under the Code of Judicial Conduct, I don't believe that I am required to recuse myself in Vanguard cases. And I would strictly comply with the ethical obligations that apply to a Supreme Court justice.
But you're not going to make a promise here that you're not going to rule in Vanguard cases while you have holdings in Vanguard when you're on the Supreme Court?
Well, what I want to say about recusals on the Supreme Court is that the decision-making process on the Supreme Court, or any court with a fixed membership, a fixed number of jurists who sit on each case, recusal in that situation affects the decision-making process, because instead of having 9 justices, you have 8, you have the potential for a tie. On the Court of Appeals, that is a much less significant consideration because we always sit in panels of 3. We have many judges on our court in many cases, so if I don't sit on a case involving Vanguard, it just means somebody else will sit on the case involving Vanguard. It will still be decided by a 3-judge panel.
I would add on that point that that may be true, but it's also true that the Supreme Court is the last stop, and if somebody doesn't recuse himself, there's really no remedy. And that is why it's so important that somebody would recuse himself.
It is very important for somebody on the Supreme Court to fulfill strictly the obligation not to sit when the person should not sit. But it's also important for, given the matters that I just discussed, for a justice to sit if the justice is not required to recuse.
Judge, my time's up. Mr. Chairman, we don't yet have the communication from Judge Alito to the clerk on December 10th, 2003 that caused Vanguard to be added to his standing recusal list. And whether that was an email or a form that Judge Alito filled out or something else, we've requested it. So I'm just asking for the assistance of the chairman in getting that document so we can complete the record.
Senator Feingold will take a look at it and see what the facts are.
Thank you.
Thank you, Senator Feingold. Senator Graham?
Thank you, Mr. Chairman. Judge Alito, maybe we could continue with the Vanguard issue just for a moment. And I know you've been asked every conceivable combination of questions, but, you know, Senator Feingold, very sincere about ethics in government. He practiced what he preaches, and he's been one of the leaders of trying to make this place operate better. And my impression of you is that you're a good model for judges in terms of ethical conduct based on what everybody says who knows you. I mean, I don't claim to be a close associate of yours, but the ABA has looked at this and said that it did not reflect poorly on you. 300 lawyers and judges who know you have said that you're just really sort of what we want in a judge. And maybe that's not enough, but that's a pretty good start. You know, I don't think you could get 300 people to say that about me or some of us, but the question I have, the criminal prosecutor or lawyer in me has this question to ask. Why would you make a conscious decision not to recuse yourself? Why would Judge Alito sit down in the corner of a room and say, I think I've got a conflict, but I'm just going to let it go and hear the case anyway? I'm baffled as to why you would make a conscious decision in this situation not to recuse yourself. Do you have an explanation?
There's no reason why I would make such a conscious decision. I had nothing whatsoever to gain by participating in this case, and nobody has suggested that I did. This case involved some thousands of dollars. Vanguard manages billions of dollars of funds. The idea that the outcome of this case could have some effect on the mutual funds that I hold is beyond preposterous, and I don't understand anybody to have suggested anything like that.
I've been asking myself that question quietly. What is in it for this guy? Why would he bring all this grief upon himself consciously? Is it to intentionally break a promise to the Senate so you'd go through hell for 3 days? I don't think so. So I'm going to accept you at your word like the ABA, and I'm going to move on. And I don't know if anybody else will. Now, your days at Princeton. The more I know about Princeton, it's an interesting place. What is an eating society?
It's the eating clubs are privately owned facilities where that upperclassmen join for the purpose of taking their meals. The first 2 years when I was there, the situation is now a bit more diversified as far as eating is concerned, but when I was there, and traditionally the freshmen and sophomores ate in university dining halls, and then as juniors and seniors they had to find other places to eat, and these were private facilities.
What is a selective eating society?
It's one where you apply to be a member like a fraternity, and you go through a process that is somewhat similar to that, and they select you if they like you.
Were you a member of a selective eating society?
No, I was
Did
not.
people not like you, or you just didn't? You just didn't apply?
I didn't apply.
Well, let me tell you who did apply. Donald Rumsfeld was a member of a selective eating society at Princeton, and that's an interesting comment, I thought. Woodrow Wilson, Jim Leach, good friend of mine over in the House. Mitch Daniels, the governor of Indiana, was a member of a non-selective eating society. Senator Claiborne Pell was a member of non-selective eating societies. And other Princeton alumni who are members of Congress could not verify their participation or lack thereof in eating clubs, including Senator Sarbanes, Bond, Frist, and Representative Marshall. And I promise you I'll get to the bottom of that before this is all done. Now, this organization that was mentioned very prominently earlier in the day, did you ever write an article for this organization?
No, I did not.
And some quotes were shown from people who did write for this organization that you disavowed. Do you remember that exchange?
I disavow them. I deplore them. They represent things that I have always stood against, and I can't express too strongly.
If you don't mind, the suspicious nature that I have is that you may be saying that because you want to get on the Supreme Court. that you're disavowing this now because it doesn't look good. And really what I would look at to see if to believe you or not, I'm going to be very honest with you, is how have you lived your life? Are you really a closet bigot?
I'm not any kind of a bigot.
No, sir, you're not. And you know why I believe that? Not because you just said it, but that's a good enough reason, because you seem to be a decent, honorable man. I've got reams of quotes from people who have worked with you, African-American judges. I've lost my quotes. Judge Hickenbottom, I don't know where they're at, but glowing quotes about who you are, the way you've lived your life. Law clerks, men and women, black and white, your colleagues who say that Sam Alito, whether I agree with him or not, is a really good man. And you know why I believe you when you say that you disavow those quotes? Because the way you have lived your life and the way you and your wife are raising your children. Let me tell you, this guilt by association is going to drive good men and women away from wanting to sit where you're sitting. And we're going to go through this ourselves as congressmen and senators. People are going to take a fact that we got a campaign donation from somebody who's found out to be a little different than we thought they were. And our political opponent's going to say, aha, I got you. And we're going to say, wait a minute. I didn't know that. I didn't take the money for that reason. And you know what? I'm going to believe these senators and congressmen for the most part, because that's the way we do our business. We meet people here every day. We have photos taken with people, and sometimes you wish you didn't have your photo taken. But that doesn't mean that you're a bad person because of that association. Judge Alito, I am sorry that you've had to go through this. I am sorry that your family has had to sit here and listen to this. Let's talk about another time, not so long ago, and another judge and some of her writings, and see if the Senate is changing for the better or for the worse. Justice Ginsburg, who I need to go have a cup of coffee with because I constantly bring her up, and I do not dislike the lady, I admire her, but let's put it bluntly. Under today's environment, from a conservative's point of view, she would have a very hard time. Because Justice Ginsburg was the general counsel for the ACLU from 1973 to 1980. And if you want me to tar somebody by their association, I can put up some pretty wild cases from my point of view where she was involved. But you know what? I respect her because her job as an attorney for the ACLU is to represent the most unpopular causes. And as far as I can tell, during her time with the ACLU, she was honest, she was ethical, and she fought for the most unpopular causes. And for that, I respect her. But you've put some things down on an application about your view of the law in Roe v. Wade. And it's taking an unbelievable effort on your part, I think, to convince people that when I was a lawyer I did this, when I applied for a job I was doing this, and as a judge I will do this. Here's what Justice Ginsburg said in an article she wrote titled "Some Thoughts on Autonomy and Equality in Relationship to Roe v. Wade." The conflict, however, is not simply one between a fetus interest and a woman's interest narrowly conceived, nor is the overriding issue state versus private control of a woman's body for a span of 9 months. Also in the balance is a woman's autonomous charge of her full life's course, her ability to stand in relation to man, society, and the state as an independent, self-sustaining, equal citizen. She wrote further, "As long as the government paid for childbirth," the argument proceeded, "public funding could not be denied for abortion, often a safer and always a far less expensive course, short and long term. By paying for childbirth but not abortion, the government increased spending and intruded upon or steered a choice Roe had ranked as a woman's fundamental right." The public funding of abortion decisions denying a requirement of public funding appear incongruous following so soon after the intrepid 1973 ruling. The court did not adequately explain why the fundamental choice, principle, and trimester approach embraced in Roe did not bar the sovereign, at least at the pre-viability stage of pregnancy, from taking sides and being required to provide funding for the abortions of poor women. If that writing doesn't suggest an allegiance to Roe, that writing doesn't suggest from her point of view as the author of that article, not only is Roe an important constitutional right, the government ought to pay for abortions in certain circumstances. If she were here today and a Democratic president had nominated her, and we take on the role that our colleagues are playing against you, not only would she not have gotten 96 votes, I think she would have been for a very rough experience. And what's changed? Justice Ginsburg openly expressed a legal theory about Roe v. Wade. My question to you, if I am arguing a case that would alter Roe v. Wade, would I have the ability, because of her prior writings, to ask her to recuse herself based on those writings alone?
I don't think you would, Senator. I think it's established that prior writings of a member of the judiciary do not require the recusal of that member of the judiciary.
I think you're absolutely right, Judge. And let me tell you what she said at the hearing when it was her time to sit where you're sitting. You asked me about my thinking on equal protection versus individual autonomy. My answer is that both are implicated. The decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. It is a decision that she must make for herself. When government controls that decision for her, she is being treated as less than a fully adult human responsible for her own choices. A sentiment that I think our pro-choice colleagues share. A sentiment that I disagree with because I think the decision does affect humanity, and that's the unborn child. I don't question her religion. I don't question her patriotism. She gave an answer that was very honest and was very direct. And pro-life Republicans and pro-life Democrats never thought about disqualifying her. She didn't go through what you went through. pro-life Republicans and pro-life Democrats set her comment aside and judged her based on her whole record and believed she was worthy to sit on the Supreme Court, and she got 96 votes. And what you've said in your writings about the other side of the issue pales in comparison to what she said before she came to this body. I don't know how many votes you're going to get. You're going to get confirmed. And it's not going to be 96. And Judge Roberts got 78. And I'm afraid to say that you're probably going to get less. To my colleagues, I know abortion's important. It's important to me. It's important to you. I know it's an important central concept in our jurisprudence. But we can't build a judiciary around that one issue. We can't make judges pledge allegiance to one case. We can't expect them to do things that would destroy their independence. You can vote yes, you can vote no, you can use any reason you would like. I just beg my colleagues, let's don't go down a road that the country can't sustain and the judiciary will not be able to tolerate. People set aside her writings, set aside her candid statement, and gave her the benefit of the doubt that she would apply the law when her time came. She replaced Justice White. We knew that that vote was going to change. I don't think any Republican had any doubt that if there was a Roe v. Wade issue, she would vote differently than Justice White, but you never know. The one thing I can tell the public about you and John Roberts is that you're first-round NFL draft picks, but I don't know what you're going to do 10 or 20 years from now, because I think you men are great integrity. And I may be very well disappointed in some of your legal reasoning, but I'll never be disappointed in you if you do your job as you see it fit. The last thing I'm going to read, do you know Kathy Fleming?
I do. She was an attorney, a supervisor in the U.S. Attorney's Office in New Jersey.
Did you ask her to write a letter on your behalf?
I did not know.
Judge Alito did not ask me to write this letter. I volunteered. I'm glad you said that, by the way. I'm a lifelong Democrat. I am the president-elect of a National Women's Bar Association. I chair the Corporate Integrity and the White-Collar Crime Group at the National Law Firm. I do not speak on behalf of either my law firm or the Women's Bar Association. I speak for myself only. But by providing my credentials as an outspoken women's rights advocate and liberal-minded criminal defense attorney, I hope you will appreciate the significance of my unqualified and enthusiastic recommendation of Sam Alito for the Supreme Court. Sam possesses the best qualities for judges. He's thoughtful, he's brilliant, he's measured, he's serious, and he's conscious of the awesome responsibilities imposed by his position. I cannot think of better qualities for a Supreme Court justice. It is my fervent hope that politics will not prevent this extraordinary capable candidate from serving as an Associate Justice on the United States Supreme Court. Sure. I share her hope. Thank you. I yield back my time.
Thank you, Senator Graham. Senator Schumer.
Thank you, Mr. Chairman. Thank you, Judge Alito. And first, I want to go over some of the things you said yesterday. Judge Alito, you testified yesterday that you'd keep an open mind. Isn't that right?
I did, and I do.
Now, are you aware of any nominee in the history of the Republic who's come before the Senate and testified he'd keep a closed mind?
I'm not aware of that, but I can only speak for myself. I would keep an open mind on all
How
issues.
about you also testified yesterday that no one, not even the President, is above the law, right?
That's certainly true.
Yes. And are you aware of any nominee in the history of this Republic, of whatever political philosophy, judicial philosophy, or denomination, who's come before the Senate, party denomination, and testified that actually there are a few people who are above the law?
I'm not aware of a nominee
Me
like
either.
that, Senator.
And you also testified that the court should have respect for the Congress. Isn't that right?
Yes?
Know of any nominees who came before the Senate and said, "The heck with you guys. I don't have any respect for the Congress"?
Senator, I can only speak for myself, and those are true expressions of what I think.
I know that. But all I want to say is, and I don't doubt your sincerity in saying them, but this morning's newspapers were filled with headlines to the effect you would keep an open mind. I don't find that really to be news, nor do I find it very helpful in figuring out what kind of justice you would be. My friends on the other side of the aisle have repeatedly said you've answered over 200 questions. Now it's probably 300. But a response is not an answer. And you've responded to more than 300 questions, but in all due respect, you haven't answered enough of them. And so, again, I think we ought to make clear that, at least to many of us here, we haven't gotten the answers to questions, yes or no, on some important issues. And with that, I'd like to return to Roe a question that something we discussed yesterday at some length. You did say yesterday that you'd keep an open mind. You said first you'd look at stare decisis, and then you'd keep an open mind after going through stare decisis. But when I asked you questions about your prior statements to see if you would keep an open mind, so I could make a determination, so the American people could make a determination, you really didn't answer the question. Now, we've heard pledges about having an open mind before. I want to read you one. It's another hearing, someone who sat in your chair. I have no agenda, Senator. I have tried here, as well as in my other endeavors as a judge, to remain impartial, to remain open-minded, and I am open-minded on this particular issue. I'll bet you can guess who that nominee was. It's Clarence Thomas, on the issue of the Constitution and the right to choose, the very issue I've asked you about when he sat in that chair 15 years ago. So someone pledging an open mind doesn't tell us very much, because I think there were a lot of people on this committee who were surprised, I wasn't there, were surprised by how Judge Thomas ruled based on his testimony. Didn't tell them enough. Now, yesterday, as you know, I asked you whether you believe today that the Constitution protects the right to an abortion. And given that in 1985 you flatly said that it doesn't, and you didn't answer that question. Then I asked you whether the Constitution protects the right to free speech, and you said yes. Then I asked how could you answer one and not the other, and your answer as to why you could discuss one and not the other was essentially that the words free speech appear in the Constitution, but that, and this is your words, the issue of abortion has to do with the interpretation of certain provisions in the Constitution, the 14th Amendment. Now, Judge Alito, the words one person, one vote are not in the Constitution. You know that. And yet, you said yesterday, and I think you repeated today to Senator Cole and maybe Senator Feinstein as well, but what you said yesterday was, quote, I think that one person, one vote is very well settled now in the constitutional law of our country. So, you were able to answer on the basis of something as to whether it's settled not being in the words are not in the Constitution. But you were queried by a few of my colleagues, and you had a different explanation. Now you said you can answer on the other issues because it's settled law. It's not going to come before the court. So let's go over settled law a little bit. In case after case, you've been telling us, you've been comfortable telling us that certain cases are settled. And yet you won't use that word with respect to Roe. You've done it in a host of other cases and issues. I'll read a few. So I think that one person, one vote is very well settled now in the constitutional law of our history in response to Senator Cole. The status of independent agencies, I think, is settled in the case law. That was in response to Senator Leahy. But I do think that most of those Commerce Clause cases in the years preceding Lopez, the ones that come to mind, I think, are well-settled precedents, reference to Senator Feinstein. I think the scope of immunity that the attorney has is now settled by Mitchell v. Forsyth, and that's the law. So, can you answer the question? Is Roe settled or not? It's less of a concern which way you answer. I'd just like you to answer the question. You can say, Roe is not settled. Roe can absolutely be re-examined. I think a lot of people think that's the answer you want to give, but it's controversial. And you may not want to give it because it's controversial, even though some of these other issues will come before the court. Commerce Clause cases will come before the court. Certain types of one-man, one-vote cases will come before the court. Certain types of administrative agencies will come before the court. So why is it only when it comes to Roe you can't tell us whether it's settled, whether it's not settled, or how it is settled? And you can pick any formulation you want. Other judges have commented on Roe being settled, and Lindsey Graham pointed out, he's not here, but Ruth Bader Ginsburg talked about her view, and she's still got a lot of votes on the other side of the aisle. Same might happen to you. So the question, Judge Alito, is, why won't you talk to us about Roe in terms of whether it's settled or not, when you will about so many other issues, even issues that would come before the court?
The line that I've tried to draw, and I've tried to be as forthcoming as I can with the committee. I've tried to provide as many answers as I could. And obviously, I'm speaking here extemporaneously in response to questions. The line that I have tried to draw is between issues that I don't think realistically will come before the court. And on those, I feel more freedom to respond. And one person, one vote is an example
What about
of that.
Commerce? Sorry to interrupt, but we have limited time. What about Commerce Clause? Raich came to the court a couple of years ago. Raich has roots all the way back in Wickard v. Fulham. You talked about Commerce Clause cases being settled.
Well, it depends on which Commerce Clause cases you're talking about. Certainly the initial Commerce Clause cases that moved away from the pre-New Deal understanding of the Commerce Clause have been on the books for a long time. Maybe I have been more forthcoming than I should have been in some areas. And if that's the case in providing these extemporaneous answers, I can be faulted for that. But the line that I have to draw, and I think every nominee, including Justice Ginsburg, has drawn, is to say that when it comes to something that realistically could come before the court, they can't answer about how they would decide that question. That would be a disservice to the judicial process.
Well, I understand your view. I just think there are some inconsistencies there. And I would argue you ought to err on the side of being more forthcoming. This is the last chance we and the American people will have to make a decision before a lifetime appointment. But I want to move on to another issue also related to Roe. Now, you did say that in 1985 you believed that the Constitution did not protect the right to an abortion. And at that time you were a mature legal mind. You were 35, you were already a federal prosecutor, you were serving in the Solicitor General's office, you had a pretty good understanding of the Constitution, you had argued cases related to Roe before the Supreme Court, I think 12 times by 1985. So you were a well-seasoned, mature, established legal mind at that time. Is that fair to say?
Well, Senator, most of what you said is certainly correct, but I had not argued any case involving Roe before the Supreme Court.
Okay, you'd argued 12 cases before the Supreme Court.
Yes, that's correct.
Okay. Now, let me ask you this. When you wrote that statement, you did not, as we discussed yesterday, when you wrote that the Constitution does not protect the right to an abortion, you had no exceptions. So that would mean at least at least in 1985, your view then, there would be no constitutional protection for a woman to terminate her pregnancy, even if the termination was needed to preserve her future ability to have children, right?
Well, Senator, it was a general statement that didn't go into, it didn't.
But it had no exceptions. You could make that.
It was one sentence, and it certainly
Right.
didn't represent
There was
an
no,
attempt.
you didn't write any exception for that situation, correct? It just said the Constitution does not protect. It was without exception, and yesterday you didn't argue with me when I mentioned that, without exception.
I don't recall you using the word without exception.
I think I
It's-
did.
Senator, it's one, well, I don't, I'm not
Okay,
disputing that.
so if you believe
Could I
that...
just answer
Yeah,
that
please.
question? It's one sentence, and it certainly is not an attempt to set out a comprehensive view of the subject.
No, I understand that, but it was a very strong statement. It didn't talk about any exceptions at all, and the way I read that statement, even if a woman was raped by her father, she'd have no constitutional protection to have an abortion and terminate that pregnancy. If you believe the Constitution protects no right to an abortion, that would follow, wouldn't it?
I think the statement speaks for itself, and it's one sentence, and it's not an effort
Okay,
to
well,
set out a comprehensive view
knowing
of
these
the subject.
examples, do you still refuse to distance yourself in any way from a broad, unqualified statement without exception that the Constitution does not protect the right to an abortion? No ands, ifs, or buts is my words, but that's what you
What I
said.
actually said was that I was proud of my participation in the Thornburg case, in which the government made the argument that it made in the
Right,
Thornburg
but you
case.
said in the
and
previous sentence of that statement that you personally held those views.
That's correct, but what I was talking about there was the Thornburg case, and nothing more than the Thornburg case.
I understand, but you haven't rethought the position at all, even knowing these extreme cases and the hardship that it might cause. You're
Well,
not
what
willing-
you've pointed out is exactly why, if the issue were to come up and one were to get beyond stare decisis, the whole judicial decision-making process would have to be gone through.
And you
We'd have to know.
you didn't think that through in 1985?
I was not involved in,
When you wrote the statement, when you wrote that statement?
and when I wrote the statement, what I was saying was that I was proud of what I had done in relation to the Thornburg case, which was to write the memo that the committee is aware of, which did not argue that Roe should be overruled, did not argue that the government should argue that Roe should be overruled, but that the decision should be challenged on other grounds that were quite similar.
I understand what you wrote, but you also, we can bring the statement up here, but I don't want to go over the thing of yesterday. I would just ask you to think of all the consequences of a broad statement, even from 1985, that the Constitution does not protect the right to abortion. It's not an exception of health of the mother, not an exception of rape or incest, not an exception of any of these others. I didn't see any of those in your job application, but I want to conclude
Senator,
on one. Go ahead, please.
It was one sentence, and I think what you're saying highlights the importance of not addressing this until the judicial process takes place, where all of this complexity would be taken into account.
In all due respect, sir, I think it highlights the importance of an obligation to discuss it, particularly in light of a strong statement before, but we'll have to differ on that. I want to go back to the cap issue in conclusion, because some of the statements just don't add up, and I just want to try to figure this out a little better. You graduated from Princeton in 1972. I'm just going to state, to save us a little time, a series of facts here. You filled out the application to apply for the job in the Reagan administration in 1985, where you mentioned membership in that group. Now, is it fair to say you joined sometime around 1972?
I think that's very unlikely,
Unlikely.
very unlikely.
When do you have no idea when you joined?
I don't, but if I had done anything substantial in relation to this, including renewing membership or being a member over a lengthy period of time, I feel confident that I would remember that.
Okay, so you don't remember renewing membership, writing out a check at a certain time, getting a magazine, this Prospect magazine, once a month, once a quarter, once a year. You have no recollection of any of that?
I don't.
Okay, well, here's what And let me just ask you one other question. I take it in 1985 you were a member of a whole lot of different groups. I mean, you're a member of the Bar Association. You might have been neighborhood. You're a neighborhood guy. I respect that. Maybe of the Neighborhood Association in New Jersey where you lived. Maybe other Princeton alumni organizations. In your 1990 application, there are a bunch of other organizations you list as being members of. So you were members of a whole lot of groups.
I was a member of some other groups, not a whole lot of
a
groups.
bunch. More than two.
Some other groups, yes.
Yeah, okay. Here's what I don't understand. I think here's what a lot of people don't understand. You're a member of other groups. You hardly have any recollection of this organization, and yet, somehow, in 1985, you put it on your application. Why did you? Why did you list that particular organization on your application when you have such vague recollection of it? Why didn't you put the National Bar Association, the American Bar Association, or one of the other groups that you were a member of? It wasn't a long list where you were trying to list. You somehow plucked this group, which you now say you have almost no recollection about, and put it on the application. And this group, as we've heard, is controversial. Just try to give us some understanding of your state of mind in 1985, why that group, with its tawdry history, even public then, although you said, in all fairness, you didn't know about it, but why that group? Why was it plucked out and put on the application?
Well, I deplore all of those statements that were shown on the chart.
Understood.
I would never associate myself with
What made you pick that group?
those statements.
I understand. I'm not trying to do that.
I think you have to look at the question that I was responding to in the form that I was filling out. I was applying for a position in the Reagan administration, and my answers were truthful statements, but what I was trying to outline were the things that were relevant to obtaining a political position. I mentioned some very minor political contributions. I didn't mention contributions to charitable organizations, and that's not because the contributions to charitable organizations were unimportant.
Well,
it's just that...
Can you reach back, because it is an important issue now, it's become one, and try to figure out your state of mind then and what made you pick this organization? What did you, I see why you picked the Federalist Society, that's obvious. Why'd you pick this one?
Well, Senator, since I don't remember this organization, I can't answer your question specifically, but I think that the answer to the question lies in the nature of the form that I was filling out. And the things that I put, I think the illustration of the political contributions goes right to the point. Why did I mention small political contributions and not charitable contributions?
Why? Can I ask you this?
It wasn't that the charitable contributions were less important. It was that they were not as relevant to obtaining a political position.
Why didn't you put it on your application in 1990? Wasn't there?
I didn't remember it.
But you remembered it from 1972 to or whenever you joined to 1985, formed in 72. Why I think you probably joined earlier is because of what you said about ROTC, which is a much bigger issue in its early history than its later history. And you remember that. You remember it up till 85, and then by 1990 you'd forgotten it. Let me just say, I'm glad, this is by way of explanation. That's why Senator Kennedy made his request. I'm glad, Senator Specter, that you've acceded to it. I think there are unanswered questions here that we really have an obligation to answer, and maybe the documents we get will give us some of those answers. Thank you, Mr.
Well, Senator,
Please.
I have told the committee everything that I can about this organization, and the most important thing I want to tell the committee is that I have no association with those comments that were made, even if they were made in letters to the editor or in articles that simply represented the views of the authors of those articles. They're not my views now. They never were my views. They represent things that I deplore. I have always deplored any form of racial discrimination or bigotry. I was never opposed to the admission of women to Princeton. After I had been there For a few months, I realized the difference between the non-coeducational atmosphere that was there and the coeducational atmosphere that I had had throughout my prior schooling. When it came time for me to join an eating facility, I chose one that was one of the most coeducational facilities on the campus.
I just can't figure out
Now,
why you
Senator
put this
Schumer,
group on.
Senator Schumer, your time is up. Senator Schumer. Senator Cornyn.
Thank you. Judge Alito, let me tell you how desperate your opponents are to defeat your nomination. Late last Thursday, your name, a name of a witness was listed relative to this whole issue of concerned alumni at Princeton that included the name of a man named Stephen Dujak. Does that name familiar to you?
Not other than from seeing the witness list.
Well, by the end of the day on Friday, his name was gone from the witness list of those witnesses intended to be called by the other party. As it turned out, it was revealed that in April of 2003 that he had authored a op-ed piece for the Los Angeles Times entitled "Animals Suffer a Perpetual Holocaust." And in that article, he wrote this. He said, like the victims of the Holocaust, animals are rounded up, trucked hundreds of miles to the kill floor, and slaughtered. Comparisons to the Holocaust are not only appropriate, but inescapable, because whether we wish to admit it or not, cows, chickens, pigs, and turkeys are capable of feeling loneliness, fear, pain, joy, and affection as we are. To those who defend the modern-day Holocaust on animals by saying that animals are slaughtered for food to give us sustenance, I ask, if the victims of the Holocaust had been eaten, would that have justified the abuse and murder? Did the fact that lampshades, soaps, and other useful products were made from their bodies excuse the Holocaust? No. Pain is pain. Well, Judge Alito, I read that to point out to you the desperation of your opponents. This was to be a principal witness who was going to come in and say why your membership in Concerned Alumni at Princeton was a terrible thing. But the fact is that I think they have stumbled by their overreaching, by demonstrating the desperation that they feel and how few ways they have to criticize your testimony, your career, your integrity, and who you are as a person based upon the facts. And I think it speaks volumes. It's clear to me, at least, that part of the reasons or the rationale given for a no vote against you by some on this committee and perhaps on the floor of the Senate will be that you have not been responsive to questions. We have a chart here that I think is instructive. This is as of 3 p.m. on day 2. We couldn't get any more current than that. But as this indicates, so far in this hearing, you have answered, or the 441 questions have been asked, and 431 have been answered, or 98%. Justice Ginsburg, and we've heard a lot about her and what she would answer and would not answer, and what her philosophy was, her beliefs, before she was confirmed by the Senate with only 3 votes. She had 384 questions asked, and she answered 307 of those for an 80% answer rate. You know, listening to the back and forth about whether you've been responsive to questions reminds me of a saying that I heard recently. I can answer the question, but I can't understand it for you. In other words, I think you've done to the best of your ability and to the limits of your ethical responsibility, tried to be responsive to the questions here. Obviously, no one can make that decision but the senators who will ultimately vote on that, but certainly the public and the world, people all across this great country who may be listening to this hearing and will be judging for themselves both the fairness of the proceeding and your responsiveness to the questions. I believe that they will conclude that not only have you been responsive, but that you've been very forthcoming in answering the questions that have been asked of you. But that, like Justice Ginsburg and others before her, you believe that it's important to maintain the independence of the judiciary, that you're not willing to make the judiciary subservient to the Senate or the Congress in order to get a vote for confirmation, and I applaud you for that. You know, yesterday I made a mistake. I know Senator Sessions confessed to a mistake, and as it turned out, I went over and talked to Senator Biden because I quoted him, and it turned out I didn't quite quote him accurately, but I told him we've corrected the record to make sure it reflected his words, because it's important to me to make sure that we're accurate and we're clear. But yesterday I made a mistake and referred to you as Judge Alito, and I was embarrassed by that, and I begged your pardon for that. But it seems to me that, and for those who may not be in on the joke, I mean, the idea is, the argument by some is that somehow you're a clone of Judge Scalia. Well, I've found for myself, everything we've heard, everything I've come to learn about you is that you're a clone of no one. That you're an individual who is particularly gifted and talented and experienced, and someone who is, notwithstanding the abuse that you suffered during the confirmation process, willing to offer yourself for public service in a very important role, and that is as a member of the United States Supreme Court. But yesterday I heard my colleague from New York put up some quotes. Now, it was late in the day, and I think most of the press had gone, and maybe that's a good thing. People had gotten tired, but you had to still sit here and listen to the questions and respond to those. But he put up a quote which was relatively innocuous on its face, and it asked about things like, do you believe that continuity in the law is important? And you said yes, and seems unarguable to me, but then he said, well, that was a quote from Clarence Thomas. And I suppose that was going to attribute to you all of the baggage that those on the left feel that Justice Thomas carries, and all of the views that he has espoused and all of his performance on the bench. Later he asked whether you agreed with another quote, and here again it was a sort of black letter law, good government quote, and you agreed that, yes, you agreed with that quote, and he said, aha, Judge Bork said that. Meaning somehow that you are carrying whatever baggage people on the left feel that Judge Bork carries, and you somehow embrace or subscribe to everything he believes. I want to give you an opportunity, Judge Alito, to tell us whether you feel like you're a clone of Judge Scalia, Judge Thomas, Judge Bork, or whether you believe that you are your own man, you come to your own conclusions based on careful study and your experience in the law. Would you comment on that for me, please?
Yes, Senator, I am who I am, and I'm my own person, and I'm not like any other justice on the Supreme Court now or anybody else who served on the Supreme Court in the past. I don't think any jurist is a duplicate of any other jurist. I think that the committee and anybody who's interested in the sort of judge I am can get a very clear picture of that by looking at my record on the Court of Appeals. And I've been on the Court of Appeals for 15 years and have sat on over 4,000 cases. And most of the cases that come to the Court of Appeals never go any further. We're the last stop in 99% of the cases, probably higher than that. And we know that when we're deciding those cases. And I think if anybody reads the opinions that I've written and the opinions that I've joined, they can see exactly the sort of jurist that I am. They will find some opinions I'm sure that they will disagree with, but if they look at the whole set of opinions that I've written or joined, they can get a very clear picture of me. And I'm not like anybody else. I don't claim to have the abilities of some of these of distinguished members of the Supreme Court now or in the past. I have my whatever abilities that I have, but they are my own.
Let me tell you what Cass Sunstein has said about you. You may be familiar with an op-ed piece that was written in the Akron Beacon Journal on November the 3rd, 2005. This is, of course, you know Professor Sunstein from the University of Chicago, a brilliant and liberal legal scholar. But he concludes in this op-ed, and this is how he describes you based upon his review of your life's work as a judge. He said, Alito sits on a liberal court, and this is an analysis of your dissents. Alito sits on a liberal court, so his dissents can be from relatively liberal rulings. None of Alito's opinions is reckless or irresponsible or especially far-reaching. His disagreement is unfailingly respectful. His dissents are lawyerly rather than bombastic. He does not berate his colleagues. Alito does not place political ideology at the forefront. He doesn't claim an ambitious or controversial theory of interpretation. He avoids abstraction. He's not endorsed the view associated with Justices Antonin Scalia and Clarence Thomas that the Constitution should be interpreted to fit with the original understanding of those who ratified it. Several of his opinions insist on careful attention to governing legal texts, but that approach is perfectly legitimate, to say the least. Judge Alito, I think it's important for people who are listening to understand that you are indeed your own man, and that you do the very best job that you can with the skills and the talents that God has given you, and that you're willing to serve, and we ought to respect and applaud you for that. And it is really, to me, demeaning to suggest some sort of guilt by association, or that you must be a clone of some other judge or someone who outside groups hold up to disrespect and ridicule. So I hope that, as I say, those listening, both in the Senate and outside, will make up their mind about you based upon the evidence that we've heard and that's available, and not based on those sort of specious comparisons. Now, let me ask you, believing as I do that you have been responsive, and expecting as I do that those who vote against you will claim that you've been non-responsive, notwithstanding the chart I showed you and your willingness to respond to the questions. Senator Schumer, who's an enormously talented and very bright lawyer in his own right, was pressing you on whether Roe versus Wade is settled. And, I've really tried to analyze for myself, when is it that judges and nominees are willing to go out on a limb, so to speak, and say, yes, that's settled law, or to talk more expansively about an issue? And when is it that they feel less comfortable, less free, more constrained by their ethical obligations or their desire to preserve the independence of the judiciary? And what I've concluded, and I'd like to get your reaction to this, is the more settled, to use the word Senator Schumer has, the more accepted in the society and our culture, the more free nominees feel to talk about it. But the more a nominee feels like this is an issue that not only is going to come back, it's going to come back soon. Matter of fact, may be on the court's docket now, the less free, the more bound by your ethical obligations you feel, the more you feel it's important to preserve your independence as a judge. And we've mentioned a couple of them, Brown versus Board of Education, which expresses a commitment to equal justice under the law that all Americans embrace, virtually speaking. You felt free to express a view on that case, have you not, sir?
I have. The line I've tried to draw is whether something realistically could come up in litigation before the Court of Appeals or before the Supreme Court. And
does that mean that you don't expect Brown versus Board of Education to be attacked, or someone to come before the court and ask that it be overruled?
I don't. There's no realistic possibility of that, so I felt freer to talk about something like that.
But you do believe, and I think with good cause, that there will be continuous attempts to address the abortion issue because of its divisive nature and because Americans are so divided on that issue, or at least some aspect of the issue. To what extent, for example, can the Congress pass laws which ban the barbaric practice of partial birth abortion? To what extent can Congress or the states pass laws that provide for minors to seek, requiring them to seek parental or provide their parents notice with an appropriate judicial bypass for those who are abused or neglected or abandoned by their parents? That is an issue that's at the forefront of America's consciousness, and really, I think, sort of the subtext under which a lot of the wars over judicial nominations are fought. Would you agree with that, more or less?
It's an issue that is in litigation now, and I think you can look at the course of litigation over the past 20 years, and you can see a number of cases, and of course this has been highlighted, in which the Supreme Court has been asked to overrule Roe, and it has repeatedly refused to do that. But there's no comparable pattern, for example, with respect to Brown versus Board of Education or one person, one vote.
Well, in the closing 2.5 minutes that I have, I mentioned the Cass Sunstein op-ed, which from my reading, even though I'm sure you and Professor Sunstein don't see eye to eye on all legal issues, he seems to be highly complimentary of you, is the way I interpreted those 2 paragraphs I read out of the op-ed piece. Now, a national newspaper, the Washington Post, on January the 1st, that's the Washington Post, not National Review, did an analysis of your voting record on the Third Circuit. They found that in virtually every type of case, whether labor, employment, you name it, that your record was no different than the average Republican-appointed judge. And to me, that is sort of said another way, that means that you're within the conservative mainstream in terms of your judicial philosophy. Now, I know that you and other legal scholars have some trouble with this approach by political scientists to try to survey your opinions and categorize them and say, well, this is who you are, because you don't decide cases that way, do you? You decide individual cases based upon the legal arguments, the merits, and the facts. Isn't that correct, sir?
That's right, and it would be a bad thing if judges started keeping these scorecards and said, oh, I've ruled a certain number of times in favor of one side. When the next case comes up, I better rule on the other side. That's exactly what we don't want judges to do.
You anticipated my next question, and that would be, if somehow it disqualifies you because of how political scientists have somehow ranked your sympathy with certain types of cases, how often you ruled in favor of one type of litigant and another, as opposed to an individual case-by-case decision-making process contemplated by the Constitution. I doubt it will be long before prospective nominees to the federal judiciary will be keeping that kind of chart. And when litigants come into court, they're going to be tempted to look at that and say, well, I've ruled for too many plaintiffs, I better rule for a defendant this time, or no, I've shown too much sympathy for civil rights plaintiffs, I better rule for the government this time, which would totally skew your responsibility as a federal judge, in my view. Judge Alito, my time has run out. Thank you for your response to my questions.
Thank you, Senator Corydon. We'll take now another break for 15 minutes. I've had requests from 2 senators on the Democratic side for a third round. We have 3 more senators to question on the 20-minute round.
We have several more than the 2.
Well, that's, Senator Lee, that's what I'd like to ascertain, so that we can figure out the schedule for the balance of the evening. We have 1 hour more for 3 senators at 20 minutes. I want to figure out what we're going to do the rest of the evening. And I want to figure out when we're going to bring on the outside witnesses
Mr. Chairman.
available tomorrow. So if there are other requests, I'd like to